I'm David Smith and this is Valley Mole, the show that digs in and around Silicon Valley, searching for insights into technology news stories, the patent wars, and the business of startups. At the home of Kodak in Rochester, New York, the WHEC news organization asks whether the possible bankruptcy of Kodak could be scaring away potential buyers for Kodak patents. And this is a potentially valid concern. The bankruptcy court does have the powers to void patent sales and other transactions that have taken place before the company went into bankruptcy if it deems they were against the interests of the creditors. So, this is a risk for potential buyers. And are there any other ways that a patent sale today could be unraveled tomorrow? The answer is yes. One of the most common concerns we see from patent buyers is when they're dealing with corporations as sellers. And the buyers want to ensure that if the patent sale represents all or substantially all the company's assets, if the patents constitute all or substantially all the company's assets, that if that is the case, they need to get the shareholder approval of the company of the seller in order to have full authority to sell those patents. The board of directors of a corporation generally has the powers to make virtually all decisions, but one of the decisions that they do not have full authority to make is over a sale of all or substantially all the company's assets. That requires shareholder approval, and this is an issue that comes up in patent sales very often. And sometimes the patent seller doesn't understand why the buyer's asking whether this sale of patents represents all or substantially all the company's assets. But it goes to whether they have to go out and get shareholder approval. And shareholder approval, when you have a large number of shareholders or you have shareholders that are spread all over the world, can be time-consuming and somewhat tedious. But it is necessary if you're a patent buyer. Other areas where we see disputes of this type are sometimes as joint inventors. If there are multiple inventors identified on the patent, each one owns full rights to sell or license the patent. And if the acquirer buys the patent rights from one inventor, but not all the other inventors have assigned their rights over, then the other inventors can own rights and they can sell them on. You could have multiple owners of those patents down the line. So this is an issue it's not really an unraveling of the patent sale, but it is an encumbrance or an issue, an ownership issue to clean title that the buyer needs to have checked out before they close a patent purchase transaction. Another topic that they need to look into is liens. If the patents are subject to liens by a third party, the lien is not automatically removed when the patent is sold. So you can have the scenario where the seller borrows money from someone, provides them with a lien on the patents, then sells the patents. The buyer pays good money for those patents, but there's a lien, they're subject to a lien. Then what happens is the lien holder can foreclose on the patents and have the patents sold, and they take the proceeds of the sale, and if there's anything left they may go to the original patent buyer. So liens are issues that need to be looked at by patent buyers. They can affect clean title to the patent, and they need to make sure the liens are totally removed before the patent purchase transaction closes. One other area, this is very unusual and it mostly affects mergers and acquisitions, but the Committee on Foreign Investment in the United States is a government body, an agency that can order the divestment of a company by an overseas buyer. So if the Committee on Foreign Investment in the United States deems that an acquisition by a foreign acquirer of US assets is a security threat to the United States, it can unravel the sale and have the assets returned to US ownership. So this is something that we don't very often see in patent sales. It does happen in high-tech sometimes, and now increasingly we're seeing these types of measures adopted by other countries. For example, China has adopted similar measures. They will investigate when a US or another foreign non-Chinese company acquires a Chinese corporation to see if it creates any concerns for security or actually for economic concerns for China, and they can order the transaction to be unraveled as well, the purchase transaction. So, patent sales can be later unraveled. Not all patent sales are final. Good lawyers will check to minimize the risks of this happening. It rarely happens because of the checks that the lawyers undertake. These checks may appear tedious, but they are necessary. You don't want a situation where you go and spend a couple of $1 billion on patents from Kodak or somewhere else and find that the sale is voided and unraveled later on by a bankruptcy court or for some other reason. We'd like to thank the sponsors of Valley Mole. Tynex, the full-service patent broker operating the world's largest patent and technology trading exchange. SVBS Silicon Valley Business School, providing unique educational materials and resources to students and teachers of entrepreneurship and technology commercialization. And ValueMyPatent.com, the only place to go for rapid, realistic patent appraisals.